Good afternoon. We're going to start a little bit early because our speaker has a plane to catch promptly at 2:30, and I want to make sure he gets out of here on time. You will get your lunch, no problem. Don't worry about that. If we haven't met, my name's Brian Paul. I'm a partner at Faegre Baker Daniels. Welcome to March's meeting. I'm glad to have you. Just a note about the next meeting. We'll be hosting Clark Neely of the Cato Institute on April 19th. And Tom Fisher is going to be introducing him, so I hope you can make that one as well. Today's speaker is someone you have seen before if you are a regular attendee. His name is Josh Blackman. He's an associate professor at South Texas College of Law in Houston. His expertise is in several areas, including constitutional law, the U.S. Supreme Court, and the intersection of law and technology. He's the author of 40 articles, 2 books on Obamacare, a constitutional law casebook. He's a prolific blogger, a prolific writer of editorials, and generally a prolific guy. So please welcome Josh Blackman.
Thank you so much. It is so good to be back in Indianapolis. I saw you once at the Conrad. I saw you once at the JW. And now I'm here at the Columbia Club. Brian, thank you for having me back. If you're interested, the reason why I have to hustle a little bit is tonight I'm going to be on C-SPAN. At 9 o'clock, they're having a live 90-minute program on the case of Yitquo versus Hopkins, a very famous Supreme Court case about due process and protection. So if you're bored and you can't fall asleep tonight, turn on C-SPAN at 9 and you will see me live. Here I am live. My topic today is the travel ban, and I think I'm also going to talk about sanctuary cities, because that's in the news. But I'll start with the travel ban. But before I get to the travel ban, there's another case I want to mention, and it's one you probably remember, Texas versus Johnson. This case considered whether a person can be arrested for burning an American flag at a political protest. The decision broke down on 5-4 lines, but to the surprise of many, Justice Scalia cast a tie-breaking vote for the flag burner. Now, Justice Scalia was no fan of flag burning. He once said, quote, "If it were up to me, I would put in jail every sandal-wearing, scruffy-bearded weirdo who burns the American flag. Long before they took the knee, they burned it," right? But Scalia said, "I am not king." Scalia felt his answer was compelled by the First Amendment, even though he disagreed with the result. Texas versus Johnson is a good gut check for lawyers. If your understanding of constitutional law overlaps entirely with your own philosophical beliefs, you may want to reassess the former. This is much how I feel about the travel ban. I'm a libertarian, and I generally favor open immigration policies. I think the idea of banning the entry of aliens from certain nations merely because those countries have been associated with terrorism is a bad idea in all policy. These executive orders will cause hardships to families and others seeking a better way of life. I don't even think this will cause much of an increase in our national security. But I put my cards on the table to say I am firmly convinced that Congress gave the president the power to take these actions. And the Constitution does not bar him from exercising the powers in the manner in which he did. So my talk today will have 5 parts. First, I want to walk you through the history of the travel ban, including statements made by then candidate Trump, as well as statements made by now President Trump about the ban. Second, I want to discuss the contents of the 3 executive orders. There are 3 versions of this travel ban, all of which have been halted by the courts. Third, I will discuss whether Congress has afforded the president the authority to take these actions. Fourth, I will talk about whether they conflict with the First Amendment, that is, the Establishment Clause. And finally, I'll give you a preview of the Supreme Court's arguments next month in Hawaii versus Trump. Okay? Our story begins way back in December 2015, when I thought maybe your governor would be president, but it was not meant to be, the former governor at least. Then candidate Trump called for, quote, "a total and complete shutdown of Muslims entering the United States until our country's representatives can figure out what is going on." Over the next few months, Trump shifted his position, calling for a Muslim ban to an extreme vetting policy of people entering the United States from certain territories. Or did he? Cue PolitiFact. During a July 2016 interview on CBS 60 Minutes, Trump told Leslie Stahl, "You can still call it whatever you want, but we'll call it territories." Was that a repudiation or a wink and a nod to the alt-right? However, a week later, on Meet the Press, Trump seemed to repudiate his position. He told Chuck Todd, "I'm talking territory instead of Muslim." Did he really mean it, or was this just fake news, right? Alas, the burden of reconciling these statements has fallen to the federal courts, and a judge in Virginia found the missing link. Rudy Giuliani on Fox News connects Trump's call for a Muslim ban with his ultimate policy. Now, you can sense some levity in my humor. This is not a function of the courts to be fact checkers. My God, even the fact checkers can't keep up with Trump. But this should not be for the courts to decide. Anyway, we come now to the inauguration. On January 20th, President Trump took the oath of office, and then 1 week later, on January 27th, President Trump signed the first executive order, the very first executive order on immigration, and it sent shockwaves through our legal order. For 90 days, certain aliens from Iraq, Iran, Libya, Somalia, Sudan, Syria, and Yemen were deemed detrimental to American interests, and they were denied entry into the United States. And then for 120 days, the refugee program was suspended. Syrian refugees, in particular, we denied entry indefinitely. Almost immediately after the order was signed, airport officials began to detain nationals of these 7 countries. Judges in New York, Virginia, Washington, Massachusetts, and elsewhere ordered their release. But this was only the beginning of the lawfare. The Washington Attorney General filed a motion for a temporary restraining order in Seattle, seeking a global injunction. This is not just a nationwide injunction, it's global. Anywhere a U.S. government official is found, he'll be bound. With only a couple hours of oral argument, a federal judge in Seattle granted a global temporary restraining order. How much analysis did his opinion have? Basically none, to a couple sentences. This was a global TRO, can you imagine? With no reasoning at all. The government appealed at the Ninth Circuit and sought mandamus to put it on hold. Shocker, Ninth Circuit denied mandamus. They sought en banc review. Shocker, it was denied. But the Trump administration did not appeal that judgment to the U.S. Supreme Court. They did not. They said, we'll try this again. Fast forward to March 6, 2017, President Trump issues the second executive order, which superseded his first one. There were some changes. For example, it removed Iraq from the list, and it made clear that green card holders were not subject to the ban. And it also shifted the focus. Rather than arguing that these aliens themselves are dangerous, the new order said the countries they're from do not share adequate information. And because there's not adequate information sharing, we can't trust that a person is who he says he is on his paperwork. Okay? Shocker, once again, these executive orders were challenged in court. They were challenged in district courts in in Maryland, and district courts in Hawaii. Okay? 4th and 9th Circuit, the best home of the legal resistance, right? Unsurprisingly, a judge in Hawaii issued a global injunction, barring the second executive order. Another judge in Maryland issued another executive order, barring it. These appeals were made to the 4th Circuit and the 9th Circuit. Shocker, they affirmed and upheld the injunctions. But then things changed a little bit. Trump went to the Supreme Court and sought a stay. And the Supreme Court, in a signal that maybe something was moving a little bit, ruled in part for the Trump administration. They said that if an alien lacks any bona fide relationship with a U.S. person, they can be denied entry. So for the majority of people who were subject to the ban, the court said, stop. But who is bona fide? I'm not going to bore you with it, but it means a close family member, whatever that entails. Mother, brother, sister, aunt, cousin, niece, nephew, God, basically the entire mishpucha, right? Everyone's included. But that was only temporary. You see, the second executive order, by its own terms, was meant to last 90 days. That's it. So after 90 days, on September 24th, President Trump issues, you guessed it, the third executive order. It was actually a proclamation, doesn't really make a difference. I'll call it the third one to make it easy. The third one added 2 new countries to the list. North Korea, actually 3 new countries. Chad, North Korea, and Venezuela. Now Chad is more or less a majority Muslim nation. North Korea doesn't send many immigrants to the United States, as you would probably guess. And, I mean, maybe Trump's mother, who knows, right? But doesn't send many immigrants. And then Venezuela, only a small number of diplomatic officials were covered. So for the most part, the order is still focusing on predominantly Muslim nations. And this third order was signed after an extensive review by the State Department, by Homeland Security, over what procedures to adopt. You know what happens next, right? Federal judges in Maryland and Hawaii issue global injunctions barring the order. It gets repetitive after all, it really does. I'm almost bored of this case, but it's still live. It's almost done, my friends. We'll be done with this in about 2 months. And by the way, Trump's going to win. Mark my words. Okay? So what happens next? Trump appeals to the Courts of Appeals. Now, for once, the Ninth Circuit is actually more responsible. It's surprising, but it's true. The Ninth Circuit ruled on statutory grounds that Trump lacked the statutory power to engage in these actions. Right? We all know if a judge has the choice of ruling on statutory grounds or constitutional grounds, they should pick the more narrow statutory ground. We know that, right? That's easy. So Ninth Circuit said statutory grounds, Trump loses. The Fourth Circuit said, nah, screw that. They went to the Establishment Clause. They found that Trump's anti-Muslim animus, reflected by his tweets and otherwise, established that he hates Muslims, and that's why he issued this executive order. Right? So the Fourth Circuit went out of its way to reach a very difficult constitutional question about the president's commander-in-chief powers in these instances. Okay, then we took another turn for the surprising. These judges were appealed to the Supreme Court. What did the Supreme Court do? The court let the entire travel ban go into effect. The Supreme Court, at least temporarily, let the entire travel ban go into effect. Now let me tell you something. We all know when I say Supreme Court, we mean Justice Kennedy. He decides what's good and what's bad, right? When Justice Kennedy lets a policy go into effect temporarily, in almost every case he votes for that side. Right? I've done the math on this. When Kennedy votes to put a stay on lower court opinion, he reverses. So this tells me very clearly that Justice Kennedy's on board to reverse the Ninth and the Fourth Circuit Courts of Appeals. Okay? So, as I was saying, Trump's going to win this. I don't know exactly how, but I think he's going to win this eventually. Now I want to walk you through the arguments advanced by Hawaii and Maryland and other states about why this action is unconstitutional. I'm not going to bother with standing, which I think is a very good question. I'm not going to bother with whether these claims can be reviewed in court. There's a very good argument that none of these claims can be reviewed, that the actions of the foreign affairs are just beyond the scope. We'll put those aside for now. Okay? So there are 2 statutes to talk about. The first one is 8 U.S.C. 1182F. And let me read it to you. It's very simple. It says, whenever the president finds that the entry of any aliens or any class of aliens into the United States would be detrimental to the interests of the United States, he made a proclamation, and for such period as he shall deem necessary, ready? Suspend the entry of all aliens or any class of aliens as immigrants or non-immigrants, or impose on the entry of aliens any restrictions he may deem appropriate. Now, if you just read that, that's like, wow, Congress is giving the president a very broad power. That's mostly correct. But what you have to recognize is that we're not talking here about a legislative power. This is an inherent executive power. By virtue of taking the oath of office, the Constitution gives the president a lot of authority that's not written down. And one of the powers that the Supreme Court's recognized is the power to exclude, the power to deny entry. They've said this is not a legislative power, it's an executive power. So you see this statute, right, 1182F, this is not giving the president a new power. It's merely reaffirming you already have this power and we're letting you use it, right? We are not going to contest your exercise of this power. If you remember back to your law school days, you recall a case, the steel seizure case, right? Youngstown Sheet and Tube Company versus Sawyer. A very famous case from the 1950s. And Justice Jackson, wonderful justice, he had served as the Attorney General, as the Solicitor General, very, very bright guy, said, when you have a situation where the President's acting on his own powers, and the Congress gives him whatever powers they have, the President is the embodiment of the United States government. He has all the power in his own hands. In such cases, judicial scrutiny should be at a minimum, right? That the court should not second guess. And it's snowing, lovely. The court should not second guess the President's power. Let me tell you, my friends, the courts have done everything to second guess Trump. Every conceivable way to second guess whether he's acting in good faith. Youngstown and the steel seizure case teaches the exact opposite lesson. So, without a doubt, the President has the authority under this statute to suspend their entry, right? He has that power. He also has it under the Constitution. But there's another statute, right? Many of you might know in 1965, Congress passed the Immigration and Nationality Act. This was President Johnson's big accomplishment, probably the most important statute he ever enacted. One of the provisions of this law eliminated quotas, right? Before the INA, immigration was subject to quotas. If you were from this country, you got an easy quota. If you were this country, it was very hard to get a visa, right? The INA says, quote, no person shall receive any preference or priority or be discriminated against in the issuance of an immigrant visa because of the person's race, sex, nationality, place of birth, or place of residence. Aha! So the opponents of the travel ban say, look, this is a violation of discrimination, right? You are imposing limits on who gets to enter based on their nationality. So there are a couple arguments in response. Okay? This statute concerns the issuance of visas. The travel ban concerns not visas, but entry. And you may not know this, but when you come to the United States and you arrive at an international airport and you're at customs, you're not on U.S. soil yet, right? You're not on U.S. soil until you clear customs. You can show up to the United States with a valid visa and not be allowed entry, and they'll send you right back home. I'll give you an easy example. If you show up at an international airport and you have Ebola, right? I don't care how good your visa is, you're not getting into the United States. They're going to turn you right around and put you in a cell. Let's say you show up in the United States, you have a valid visa, you're healthy, but you're talking to the consular officer and he says, I think this guy's lying, right? He finds inconsistencies in your story. Guess what? You're not coming in. The law treats admission and visas as different categories. This statute only speaks to visas. So I don't think there's even a tension between an entry ban and discrimination on the basis of visas. But let's say I'm wrong. Like, let's say that there is, in fact, some sort of tension here. The very next paragraph of the statute says, nothing in this paragraph should be construed to limit the authority of the Secretary of State to determine the procedures for the processing of immigrant visas. So even though you have this nationality ban, the Secretary can make procedures that consider nationality. Okay. When you're talking about national security, you have to read statutes in a way to avoid infringing on the President's own executive powers. This Section B, the subparagraph, gives you that way. You can say, it might not be the best reading of the statute, but it allows the procedures to be made to avoid constitutional doubts. Let them make this travel ban with restrictions on visas to avoid the problem that someone shows up at the airport and won't be let in, right? I think this is how the President wins the case. So I don't see any statutory problems with the entry ban. Okay? But then we go on to the constitutional question. All right? Does the Constitution, does the Establishment Clause put limits on President Trump's ability to implement this order? And the basis of this is nothing on the executive order, right? If you read the executive order, it's neutral. It doesn't mention Muslims, It doesn't mention Islam. It says nothing about religion, right? This is not like Korematsu where you have those big signs saying, all people of Japanese descent, please report to these camps. The executive order itself is facially neutral. But is there an improper motive behind it? In fact, tonight I'm going to be on C-SPAN talking about the case of Yikwo v. Hopkins, a very famous case from 1886. Get the year right, 1886. And this was a case in San Francisco where, at the time, one of the most common professions for Chinese immigrants was laundromats, right? They ran laundry shops. The city passes a law that says if you want to have a laundry shop in a wooden building, you need to apply for a permit. Okay? Oh, what's the big deal? Permits for everything. There was no standard, right? You didn't have to show you were safe or maybe had ventilation, just used to apply for a permit. What were the standards used to issue permits? Random, arbitrary. There were no standards, right? As it turned out, all the white people that applied for permits got them. And all the Chinese people who did get the permits, who applied, were denied permits. So you had one guy, his name actually wasn't Yikwo, that was the name of his laundry shop, his name was Li Yik. And they threw Mr. Li Yik in jail for failing to pay a $10 fine. He sued out a habeas corpus writ, and the Supreme Court actually said, let him go. They said, even though the law is facially neutral, it's being applied with an evil eye and unequal hands, right? The manner in which it's being executed falls disproportionately on Chinese people. They said this is a random, arbitrary case. It's a violation of both due process, because it's random, and equal protection, in that it's a classification that affects certain people. So we have the travel ban, right? It falls, I think, predominantly on people from predominantly Muslim nations. And Trump has basically told us on Twitter that he thinks we have a Muslim problem, that he thinks we should suspend entry of Muslims, and that all these, you go down to Twitter, he's offended everyone, right? Now, as a threshold matter, I'm hesitant of courts looking at presidential statements. For certain, they should not be looking at statements from the campaign trail for a couple of reasons, right? First, candidates say stuff to get elected, right? I don't need to remind you of this. Candidates will say the most extreme thing during a primary to get elected, and then, much to our chagrin perhaps, they move to the center during the general election, right? Trump is a showman. I don't know what he believes. Maybe he does, maybe he doesn't. But he will often say dumb things to get people excited, and I think it's problematic that courts cite that. But as a general matter, pre-campaigns, or statements in the campaign trail should be out. Those have no place in the courts. These were not vetted. He didn't have a government. He hadn't taken the oath of office. I think those statements are simply out. Okay? Post-inauguration statements, I think, can be used. I think they are fair game. You are the president. You can speak for the nation with one voice. But the problem is the post-inauguration statements don't make the point. In fact, Trump actually got a little bit smarter. He stopped saying some of the bad things he was saying before, right? But let's say that these statements are relevant, right? Let's just say they are. Is the First Amendment even applicable in the context of immigration? That is, do people not in this country benefit from our establishment clause? All of the courts who have ruled against Trump have ignored this question, which I raised over a year ago. And I've yet to see anyone respond to me. I made this point in writing, and no one has responded. They said, well, black and whatever, we don't care. Okay? But does the First Amendment apply outside the United States for the Establishment Clause? It's not obvious. And I'll give you a couple pieces of information to suggest that it's just not applicable. We have in immigration law various visa categories. There are so many categories that make your head spin. But one of the categories is for ministers, right? If you are a minister, you get a special preference for visas. You get a special preference for visas. What's a minister? It defines it as someone with a lifelong vocation to religion, like a nun or a monk or a brother or a sister, right? The statute and the regulation used Catholic clergy as an example of who gets benefits. What if you're a part-time, priest in the Church of Universalism or something, right? Are you getting a visa? No, you're not. So the statute expressly incorporates religion and a specific article of faith, Catholicism, into its definitions. This statute's been in the book for decades. Has anyone ever challenged his showing as an animist or a disfavor of Islam or anything else? Of course not, right? No one thought this even applied overseas. I'll give you an even clearer example. In the 1980s, Senator Lautenberg of New Jersey enacted what was called the Lautenberg Amendment. And this law granted a preference for, quote, Soviet Jews and evangelicals. It says in the statute that if you are a Soviet Jew or an evangelical, you get a preference when applying for asylum status. Now again, can you imagine a statute that on its face singled out Jews and evangelicals, but excluded Hindus and Muslims? Can you imagine that? The ACLU would sue in 5 seconds, right? They wouldn't be able to help themselves. Yet the statute has been on the books for 3 decades, and no one's ever questioned it. The Soviet Union doesn't exist anymore. Maybe some people wanted to, but it's gone. But we still have this statute. So as a matter of first principles, I don't think the Establishment Clause even applies here at all. It doesn't apply. And if it doesn't apply, then Trump is fine. His statements, I think, are unfortunate, and I wish he would delete his, if someone deleted a Twitter account for Lent, Trump's just going Twitter deletion for the rest of his presidency. He'd be a much better executive, I would be. If you just took out the tweets, it would be okay. Anyway, just whatever. Okay. But I think Trump will win. The Supreme Court will hear arguments in the travel ban next month, I think April 25th, if my memory serves. And I think the court will give a much more welcome reception than have the lower courts. The lower courts have been really hostile to President Trump. They go out of his way to cite his tweets when it's not really necessary. They go out of their way to, challenge his good faith and argue that he's a bigot and that he hates Muslims. And maybe it's not necessary to the case. I don't think the Supreme Court will cite tweets, right? I don't think the Supreme Court will ask him about cable news and Rudy Giuliani. I just don't think that will come up. So I do think President Trump will prevail at the Supreme Court. It might not be 5-4. I think there's a chance that Breyer and Kagan may come along because they'll recognize something. Whatever the court says with executive power today will limit not just President Trump, but future presidents, right? President Elizabeth Warren, President Malia Obama, whoever happens to be, right? Right. Yeah, I'm sorry to make you lose your lunch, right? Whoever happens to be. But when the court speaks, it speaks not just for today, but for generations to come. And I think that will affect how they resolve this. Okay? So that's the travel ban. Let me move on to the second topic I want to talk about, which is sanctuary cities. This is actually a preview. The Wall Street Journal is publishing an op-ed I co-authored with Ilya Shapiro from Cato. It's going to be published on Wednesday, so I'll give you a preview of that talk. So, we had an election, right? Not everyone agreed with the results. California's 55 electoral votes were not enough to stop Donald Trump and his pledge to increase deportations. Following last year's inauguration, California enacted 3 so-called sanctuary measures that were designed to make it harder for immigration officials to perform their missions. Here, California continues a long and mixed legacy of states resisting unpopular federal policies. On the one hand, abolitionist states like Pennsylvania actively thwarted the Fugitive Slave Act by throwing slave catchers in jail. Okay, that sounds good. On the other hand, South Carolina, led by Senator John C. Calhoun, nullified federal tariffs to protect its slave-based agrarian economy. Now, while states maintain the power to police their own local matters, they cannot interfere with federal law, which the Constitution proclaims is the supreme law of the land. California's 3 sanctuary policies, which Attorney General Sessions challenged in a new federal lawsuit last week, fall on both sides of this line. By the way, I was actually in Sacramento the day this new lawsuit was announced. I was there by chance. And a friend was able to get me in to see the Attorney General's speech, and I gave a debate on it 2 hours later at a law school, so I'm ready for this, right? Always on the fly. So there are 3 laws, right? First, Congress lacks the power to interfere with how a state structures its law enforcement agencies. California is actually within its sovereign powers not to cooperate with federal immigration officials. So in that part, I think California wins. That's it though. Second, while states can of course inspect state-owned detention facilities, they cannot single out federal facilities for heightened scrutinies. Okay? And finally, states cannot punish private business owners who voluntarily comply with federal immigration laws. While I am a supporter of federalism and of comprehensive immigration reform, U.S. v. California is an important step towards reaffirming the constitutional order and resolving simmering tensions between federal and state powers. So, the first challenge statute is called the California Values Act. Who could oppose the California Values Act, right? Who could oppose that name? It's a wonderful name. You don't like it. You don't like California values. You like Indiana values, right? Who's your values? Damn straight, right? The California Values Act limits how state officials can cooperate with federal immigration officials. Specifically, absent a warrant from a judge, local agencies cannot provide the United States with information about an alien's release date. This policy will create risks for law enforcement personnel, right? Instead of arresting a suspect in or immediately outside a secure facility, now federal agents will have to perform a public arrest in a more dangerous location. These are legitimate policy concerns. It will put federal officers at risk. I don't question that for a minute. But that doesn't render this policy unconstitutional. States retain the sovereignty to manage their own agents and are under no obligation to affirmatively assist federal agents. The Supreme Court recognized in Arizona versus the United States that states cannot enact laws that interfere with Congress's plenary powers over immigration. The California law doesn't interfere with any federal law. This policy of non-cooperation no doubt makes enforcement more difficult and more dangerous, but does not rise to the level of unconstitutional interference. Now, Attorney General Sessions counters that the California Voters Act conflicts with the federal law, Section 1373, under which a state or local government may not prohibit the exchange of information regarding an individual's immigration status. So the threshold matter, Section 1373, does not force or commandeer state agents to enforce federal immigration policy. Rather, Section 1373 places limits on the state's ability to enact their desired laws. It is generally true that Congress can preempt or disable states from legislating on areas of federal concern, like immigration. But Section 1373 goes too far because it controls an aspect of state autonomy that is inherently local. How law enforcement manages the resources and prioritizes their mission. So long as the decision not to share information about an alien's release date does not interfere with federal immigration laws, and it doesn't, then Congress lacks the power to issue this mandate. There is no doubt this mandate is useful, or in constitutional terms, necessary for the enforcement of immigration laws. But it is not a proper exercise of federal power, because Congress cannot interfere with this aspect of the state self-governance. So I think the court should uphold the California Values Act and preserve this sphere of state autonomy. It's going downhill from there, right? The second century policy instructs California's Attorney General to inspect and review publicly and privately owned detention facilities in which non-citizens are being housed. There's no problem if California wants to inspect its own state facilities. That's no problem. But it is a problem when the state targets private facilities that contract directly with the federal government. While the states retain the power to review federal facilities generally, for example, county health inspectors can check out the cafeteria in a federal courthouse, states cannot burden a specific exercise of federal power with additional constraints. Targeting federal agents for heightened scrutiny violates the so-called intergovernmental immunity doctrine. Intergovernmental immunity doctrine. Never heard of this, right? But this has roots. 2 centuries ago, Maryland sought to impose a special tax on the unpopular Bank of the United States. You have flashbacks, right? In the landmark case of McCulloch versus Maryland, God, it goes back, I'm sure. Chief Justice John Marshall ruled that the Constitution does not give the state power to destroy this federal institution. He wrote, "The power to tax involves the power to, oh, you guys are good, the power to destroy. That's where it comes from, by the way, Marshall. For the state lacks the power to control the constitutional measures of the federal government, which the Constitution declares to be supreme. You can't single out the feds for special treatment that punishes them. So through this novel regime, California's Attorney General, Javier Becerra, isn't merely inspecting all federal facilities in a neutral and consistent fashion, but, according to General Sessions, has demanded access to various private documents respecting the welfare of persons detained by the feds. He cannot do this as a state attorney general. To the extent that California is imposing additional burdens on federal immigration facilities, and those burdens are not imposed on any other federal properties, no one else, this sanctuary policy is unconstitutional. The final challenge statute is called the Immigrant Worker Protection Act. Sounds great, right? This is the worst of the three. Before the law was enacted, if a federal immigration officer informed a business owner that he employed a criminal alien, all right, you employ a criminal alien, the proprietor could consent to a search of his premise, okay? No longer. Now the proprietor, who's simply trying to promote public safety, is punished with a substantial fine up to $10,000 if he cooperates with a federal officer who lacks a warrant. Again, if a business owner says, I consent to a voluntary search, so you go arrest this criminal alien, the business owner gets a fine. It's madness, okay? Neither the Constitution nor federal law mandate a warrant in such scenarios. California's law has added additional burdens for federal immigration officials, and no other federal immigration. No one else, just immigration. Okay? And again, by the way, if an EPA investigator shows up, consent, right? If an OSHA investigator shows up, you can consent to a search. But if an ICE agent shows up, $10,000 fine. You can't do this. This law interferes with a congressionally mandated mission. Therefore, the Immigrant Worker Protection Act is preempted, trumped, as it were, by federal law. This provision is unconstitutional by virtue of both the Constitution's Supremacy Clause as well as the Intergovernmental Immunity Doctrine. So, in sum, under a federal structure that contemplates dual sovereignty, the national government should respect the spheres of state sovereignty, while states likewise should respect Washington's constitutionally granted prerogatives. Resistance of unpopular federal laws, whether for tariffs, or immigration, or marijuana, or guns, or whatever else, is permissible only within the bounds of federalism. Thank you all so much, and I welcome your questions. Yes, sir, in the back.
The statute that you referred to in the first part of your presentation, the 8 USC 1187.
82, very good, close.
Yeah, 82. Can't hear better. The first part, you can't discriminate on the basis of a number of different things, and the second part says, though, that the Secretary of State can issue whatever procedures are necessary. Have they thought about doing something like saying, okay, anybody that wants to get a visa must show records going back 10 years that are officially stamped and so forth? I mean, put a layer in there that these countries can't possibly.
Oh, I see. So the question is, the Secretary of State can create procedures that will consider national-based discrimination. So what he asks is, why can't you put some sort of impossible burden, right? So like a decade of records which simply don't exist. I don't know. I think that's actually a decent idea, right? Rather than having a blanket ban, make it so onerous that no one will be able to comply with it. I think that might be a better thing. Part of the problem with this entire litigation is that the Trump administration's initial rollout was an absolute disaster, right? And let me just walk you through this, right? Trump didn't tell anyone he was signing it. Didn't tell ICE, didn't tell Homeland Security. So imagine, you got on a plane, let's say in London, right? Friday afternoon, London time. Your visa was in order, your papers are valid. As you were crossing the pond, right, Trump signs his executive order. You can't get in. So by the time you land you are stuck at the airport and you're going to be detained for a couple days. Had Trump simply issued his second executive order initially, I don't think it would have been enjoined, right? It was such a sloppy rollout. And I think that part of it, and your question is well put, they're trying to backfill and justify what they did in the first order with number 2, number 3. Again, if they had not such a sloppy rollout, I don't think these courts would have granted global injunctions. Say, look, we're signing this policy today, we'll let it go into effect in a month, right? Calm. I think it would have been fine. But Trump wanted to, shock and awe Steve Bannon, the entire thing that was back then, right? Deconstruct the administrative state, whatever it was. It was a mistake. You don't announce such a significant policy on a Friday afternoon without any notice. The courts just freaked out. They went crazy. They didn't know what to do. They reacted, I think, in an utterly inappropriate way. But you can see where they're coming from. It's like, what is this? We got to stop this now. We are the courts. But I think your proposal might be a little bit smarter than theirs. Okay, other questions? Yes, sir.
I have one practical question and one predictive question.
Yeah.
The practical question is there any time limit on the current ban, and is there a way on which to get yourself off the ban? And the second question is, my memory is, and correct me if I'm wrong, that the first Supreme Court order as to the second ban was unanimous, but there was a concurring opinion trying to limit the language of the majority opinion. If I'm right about that, could the opinion in this case be unanimous?
Very good. So, the first question is, are there limits to this travel ban? There's no duration on the third iteration of travel ban, right? It doesn't say this is in effect for X days. What it does say is that every 180 days it'll be reviewed, but there's no endpoint. And the challengers of the ban have actually argued that the fact that there's no endpoint suggests that this is unconstitutional, right? That this travel ban must be of a limited duration, because the statute says that they can suspend entry for such period as he shall deem necessary. The fact that it says the period he deems necessary means there's a finishing point, right? That's why I think the Article 2 argument is very important, because the president has this inherent power. He doesn't need to rely exclusively on the statute. He has his own powers. Now, the second question, could this be a unanimous decision? There was some dissent from Sotomayor and Ginsburg along the way. So they seem unhappy with this. I think this might be 6-3, might be 7-2, I don't know. But the bottom line is there's a lot of how do you put this, shaming going on, right? If you read the media, they say if the judges uphold this, it's going to be the next Korematsu, right? It's going to be the next Dred Scott, right? There's a lot of efforts to portray this case as, these anti-canon cases that should be ignored. You have to keep in mind, Korematsu involved U.S. citizens. They were in the United States. There's a very important difference between people who are inside the United States and those trying to get in, right? The law provides a lot of protections for aliens in the United States, right? If an alien gets pulled over, he gets Miranda warnings, right? He gets the Fourth Amendment. He doesn't get free speech rights, doesn't get the right to bear arms, which are perhaps different issues, but he gets a lot of the criminal procedure protections. But if you're outside the United States, you get bupkis, right? Which is why I punted on this question earlier, but I don't know that any of these claims are justiciable, right? Right? These people have family members in the United States who perhaps have standing to apply their visa and the like, but I don't think that people outside the U.S. can have these constitutional questions even raised, because I don't think they're protective of our Constitution. And there's a point, I think the Establishment Clause just doesn't apply. But I don't think the court will go down this road. I don't think they even need to. What I think will happen, though, is that the court will find that there's this inherent power. You got to read the statute to comply with that, and I think they'll duck the First Amendment question somehow. Maybe the tweets aren't relevant. Maybe the tweets are relevant, and it's still fine. I don't know. What do I know? Questions? Yes, sir. With the tie, the number 2. Yeah.
Yeah. On the third one about the California law prohibiting private business owners from cooperating with ICE officials. Is there anything to be made on a First Amendment argument that if it's purely relating to information being discussed as opposed to, yeah, you can come on my property and look at my records, they are free to discuss whatever they want to discuss?
Yeah, someone raised that point earlier. There's a clause in the Constitution called the petition clause, right? That you have the right to petition the government. I think there's a credible argument this is a limitation of free speech, that if a business owner wants to talk to the federal agents about safety concerns, this statute fines that, right? Actually, I mean, it's not a criminal sanction, it's a civil fine, but $10,000 a day, right? People can't afford to just pay that. So I think there's a First Amendment question there. But beyond that, and let me make this point very clearly, you don't need a warrant for voluntary search, right? If any of you are ADAs or prosecutors, if the cops persuade you to consent, you're toast, right? But cops are good at that. Say, oh yeah, we just look around for 5 minutes. Another point, while you usually need a probable cause standard or warrant to arrest someone, not in immigration contexts, right? Civil authorities, immigration authorities, it's a civil matter, and they can arrest someone they suspect of being here illegally short of probable cause. They can do that. So California is imposing additional constraints, right? Additional constraints that neither the Constitution nor federal law mandates. This one, I think, is going to be struck down easily, right? Because it's punishing private business owners who want to comply. This is not the state's business to do this. And the question right behind, yes?
Does the nationwide injunction affect or embolden this judicial resistance on the front end, or does it just make it more powerful in the back?
Okay, so the question was about nationwide injunctions. Nationwide injunctions aren't new, right? But they're being used much more often. I did the math. Throughout the entire Obama presidency, I think there were under 20 nationwide injunctions. And some of them were big, like immigration, some of them were small, things you don't care about. In the first year of the Trump administration, there were 20, right? So however long they've existed, they're being used much more. There's also a difference in how they're being used. The template for the Obama case was that a lawsuit we brought, usually in Texas, where like 25 states would join in a single case. Here, the blue states are spreading their assets, right? They'll seek an injunction in Virginia, in the Fourth Circuit. And they'll seek an injunction in Hawaii, in the Ninth Circuit, right? And they'll seek an injunction in New York, in the Second Circuit. And they just hope they have to get one, right? They only need one judge. Because once a single judge issues a nationwide injunction, it's over, right? The ballgame's over. And then you have to run to the Court of Appeals to get a stay. And as you know, getting a stay is not easy, right? They don't have to. And then you have to run to the Supreme Court and get a stay from them. So with the idea of the nationwide injunction, where you're following it in multiple districts, the plaintiffs have to win just once. The government has to run the table, right? The government has to win in every single district. Because the second one judge issues a nationwide injunction, it's over. And we all know, judges are reversed. It happens. Right? Why should a single judge who can be reversed decide this issue definitively? And just last week, we had a case involving DACA, which I don't have time to talk about today. President Trump tried to rescind the DACA policy, the deferred action policy. Judges in Brooklyn and San Francisco said, you can't do this. But a judge in Maryland said, yeah, you can do it. So now the judge in Maryland is worthless, right? He said this is valid, but because he came third, and you have the other nationwide injunctions, it's irrelevant. So when you combine this multiple lawsuit form shopping with the nationwide injunction, it puts the government to a very difficult burden. My own prediction is at some point the Supreme Court will weigh in on this. They'll say, we don't like this because it makes us get involved early on. We don't have a full record, right? We're up here in a PI or a TRO. This is not how federal litigation ought to work. So I think at some point the courts will intervene. Congress can also intervene. Federal courts are courts of limited jurisdiction, right? And there's actually a proposed bill, I think it's very good, but a proposed bill to actually narrow the scope of nationwide injunctions. I don't know if I support that bill, but there is movement. The other issue is Rule 23, right? There is a process for certifying a class to bind people beyond those who were in the case. But there are protections for class members in Rule 23. If you do civil defense law, you know how to kill a class. When you have a nationwide injunction, there's no certification, there's no process, it's just boom. So I think at some point we're reckoning here. It's being used very effectively by Republican AGs and now by Democratic AGs. I think the gravy train will stop eventually. Very good question. Anyone else new? Yes.
Do you think President Trump will just begin ignoring federal orders?
Yeah.
Well, because even Justice Scalia, before he died, said, I care very much about whom I'm ruled by, and, the federal courts will be seen as impotent if they don't abide by rule of law. Are you concerned that President Trump is the president who's going to pull Andrew Jackson or enforce your own federal order?
Yeah, the question was, you couldn't hear it. Will President Trump be the first one to simply tell the courts, not going to follow your ruling. I'm doubtful. Trump is very good at blustering, but when it comes down to it, he usually doesn't do the thing that people want him to do, perhaps. He's made a lot of very harsh comments in the courts and disparaged judges. By the way, the judge, remember some time ago he said there was this judge who was Mexican, wasn't being fair to him. That same judge actually ruled in favor of Trump on the wall, right? He actually gave Trump a victory. So I think our judiciary, although they make mistakes, is still on the whole pretty neutral and balanced. But I think Trump's lawyers will tell him if he started ignoring the courts, it could create a much bigger ripple effect. But let me take your question a different way. Hamilton wrote in Federal 78 that courts don't have the power of the sword or the purse, they only have the power of judgment. And some of these judgments have, I think, blurred into will of the judges, and they've overreacted to the entirety, the insanity of the Trump typhoon, right? They're just overwhelmed by it. And I think when the Supreme Court reverses all of them, which I think they will, they'll have a day of reckoning saying, wow, maybe we screwed up. Or maybe not. Life tenure means you don't have to think about your actions. It's an important, it's a cushy part of the job. But I've watched very carefully in the last year and a half how lower courts have treated Trump. And I've noticed that there's been a bit of a settling down, right? Initially the opinions were like just this rabid red meat, like, oh, tweet. And now the Ninth Circuit's like, well, let's rule this on narrow statutory grounds, right? We don't need to cite Twitter. So I think there's been this equilibration, if you will, of how the courts have settled down with respect to Trump. I think that's positive. I mean, a lot of them are responding to me. I know they are. I know they read my stuff. One of these judges in Brooklyn actually cited two of my articles in the docket saying why I was wrong. Actually, what he said was, DOJ didn't raise Blackmun's argument, so I won't consider it. Oh, come on, DOJ, do your job. Do your job. Read my stuff. But I think your question's well put, right? Your question's very well put. If the courts keep acting beyond their bounds and don't have a proper respect for the democratic elections, their own legitimacy is at stake, right? It's not only about Trump wounding our republic, it's also about the courts wounding our republic. It's not just one-sided. We all want to talk about limiting the president's power, but the courts perhaps are exercising too much of their own power. So this is a very fair point.
Yeah, but I think
question right here? Yes.
has already been done.
Yeah, a lot of the damage has been done. That's true. Other questions? Okay, yes, sir.
Just real quick, if I understand the California Values Act, then that's a state law prohibiting a citizen from reporting a federal crime, and that would prohibit, for example, I think I heard this, landlords from saying, hey, there's 20 people living in a basement next door, they can't report that. And part two, what's the fine for violating that?
Well, the Values Act refers to state law enforcement. I think you're thinking of the third one, which was the, I can't remember what the hell it's, the Immigrant Workers Protection Act.
Okay.
That applies in places of business. I don't recall if the statute applies it to residential. I can check that later, I'm not sure. But what it does say that if you allow a federal immigration officer to conduct a search and he has no warrant, you will be fined. I think it's up to $10,000 a day, which is basically going to put you out of business. It's impossible to actually do that. And the Attorney General said we will prosecute this, right? It's a civil fine, but it's prosecuted by the AG. So if you have an insurance policy for your business, they're going to tell you don't consent to searches because that comes out of your general liability.
Wouldn't that trigger?
I'm sorry, what's your name, please? Yeah, sir. Which one? Yeah, good. What's your question? Yeah.
Okay, so I'm a landlord, and I find out or determine that next door there's another building, and all these illegal aliens are living there, and I report it, and you fine me for this because they didn't have a warrant. Isn't that an actionable act? I mean, I can sue the government and say you can't do this.
Yeah.
Can I do that?
Yeah, I think someone raised that point a minute ago.
Yeah.
I think it's a free speech issue.
Yeah.
You can petition the government for redress of grievances. This is actually penalizing you for complaining about illegal conduct. I think that's absolutely.
Yeah.
I think there will be subsequent suits to the extent that a prosecution is brought. You have an as-applied challenge. I think this will come up. Good point. Other questions?
Go to the airport, Josh.
I went to the airport. Thanks so much.
Our next event, again, is on April 19th with Clark Neely and Cato Institute. I neglected to mention the title of this program.